You always include, I don't know if I actually have it in this one, but we do always include a little disclaimer. This is just legal education, not legal advice. So I'm going to be kind of walking through the basics of what a copyright is, because that's sort of crucial to have that as your foundation, and then it helps to understand the more complex areas as we go. So we start there with the really just basic premise of what a copyright is. So it's a piece of property. It's a form of property, and I could draw out like a whole family tree kind of thing, but under US law we have a division of the law that covers just property. Underneath that it splits out into real property, which is land and buildings, and personal property, which is basically everything else. Under personal property you have tangible property like the chairs in this room, or even your instruments, or anything else you can see and feel. But underneath that category of personal property, the other one you have is intangible personal property, and that's where copyrights fit in. So not just copyrights, but also trademarks, patents, things like bonds and securities, things like that. Those are all forms of property, and so on a basic level, in terms of your ability to buy and sell them, to give them away, to lease them out, things like that, all in a very basic level, the details start to diverge, all are basically governed by the same concept. So when you think about your ability to transfer property to another person, just kind of keep that in the back of your mind, because you can do that with copyrights as well.
So I have a question already about copyright. Now, it's my understanding, correct me if I'm wrong, that in terms of music, when you write a composition, the actual act of writing on a piece of paper means that it's copywritten. I mean, I know it's not protected.
That is true on a basic level. So I'm actually going to get to that in the next slide or two.
Okay.
But the way that copyright, sort of in the world of all of the different forms of property that there are that are legally recognized by our government, copyright is defined as a set of exclusive property rights. So it's essentially a monopoly that belong to the creator of a piece of, in this case, music, but there are a lot of things that are eligible for copyright for a limited period of time. And that's a really important thing, because basically you get this monopoly, but the trade-off is that you only get it for a fixed amount of time. So you may have heard of like patents being something that go into the public domain relatively quickly. The duration for patents is only 20 years. So after 20 years are up, a specific invention that is covered by a patent falls into the public domain. With copyright, the duration is quite a bit longer. It's the life of the author, who's the person who created the work, plus 70 years after they die. So the rationale there is that 70 years allows for enough time for at least one, but hopefully more than one generation following the artist, their heirs, can continue to monetize that work even after the artist has passed away. I'm going to do this just so that my computer doesn't go to sleep as quickly as it would if it's not plugged in. So life plus 70 is the key thing to keep in mind there. That's the rule for individual authors. If you were, say, Disney, which is a corporation, anything that comes out of Disney as a corporate author actually has a different set of duration rules, and there's two rules there. It is either 90 years after the publication of the work, so once it's released to the world so that people can go see the movie in theaters and all that kind of stuff, or if it never gets published, if it stays in the Disney vault or something like that, then it's 120 years after the creation. So that usually doesn't come into play in the music context, but just something to keep in mind is that life plus 70 thing contemplates the life of a real human person plus those 70 years after they die. So in music, okay, go ahead.
So that means, somebody who died in 1949, we can legally play their compositions now, essentially?
Yes.
No, it has to do with their heirs too, because it's 70 years plus.
So
it's the life of the author plus 70. Okay.
Right. So if they died in 1949, 2019 is 70 years later. Under that basic rule, yes, 2019 would be the year that work falls into the public domain. It's actually, the real answer is a lot more complicated than that, because the US Copyright Act, which is the actual statute that codifies all of these copyright rules, was revised and updated probably 3 major times during the 20th century. So in 1949, there was the 1909 version of the Copyright Act in effect, but then it was totally overhauled in 1972 and passed into law in 1976, and so we are now operating under what is known as the 1976 Copyright Act. So all of the rules that we have today are part of the updated statutory regime, and works that were created prior to that are subject to all of these like gap filler rules to try to extend and make all these provisions. It used to be the case that you had, after you copyrighted a work, you had to renew it after a certain period of time, but all of that was changed in the 70s as well. So the basic rule that's important for artists who are functioning and creating their works today is that it's 70 years after you've passed away. So
Plus that copyright could have been sold to another company, right? Or to
yeah. So
if they sold to Sony, then you
Right.
might as well.
well, so that whole corporate author rule only applies, and I'm going to get to the distinction between author and owner in a second, but that only applies when the creator of the work is some corporate entity. So if you've created the work as a real live human and then sold it to somebody else, the duration of life plus 70 is still in effect. So even if Sony owns all the rights now, your copyright is still going to go into the public domain 70 years after you die, regardless of who owns it on the day of your death. Okay. So the copyright law recognizes a few different categories of works. We have things like works of what are known as pictorial, graphic, or sculptural works, which is visual art, right? So paintings, drawings, photographs, sculptures, things along those lines. In fact, Mardi Gras Indians, about 7 years ago, were able to obtain a copyright registration with the U.S. Copyright Office in their suits as soft sculptures, and that's the first time that they were ever able to get copyright protection over that. So anything that you view as a sculpture, so the reason that Mardi Gras Indian suits are able to do that is they made the argument that it's not clothing, because it's not functional as clothing. The suits are really heavy and really hot, and they only wear them 1 or 2 times a year. And so they were successfully able to make that argument that they're sculptures. So you've got that, right? You also have works of performing arts. So that means choreography, plays, films are kind of loosely included in that, though they're under a different kind of subcategory. But the other thing that's considered a work of performing arts is a musical composition. So the actual written song, not necessarily how it sounds on a record. The musical composition is one type of copyright, but then you also have a separate copyright in the sound recording. So when you just sit down at the piano and write a song, you've created a musical composition, and as soon as that work is fixed in a tangible form, which I'll get to in a second, the copyright exists, okay? But there's no copyright yet if you haven't recorded it in the sound recording. So once you then go into the studio and record everything and do all of your tracking and whatever else you need to do, layer on more instruments and all of that, then you've created a new work, this sound recording that's based on the musical composition, but copyright law recognizes 2 separate pieces of property there. And that distinction is really important because in the music industry, musical composition is what's known as your publishing rights. It's why you work with a music publisher, all of that. Now on the other side of that coin, because these are inextricably linked to each other, the other side of the coin you have your sound recordings known as masters in the music industry, and that's what record labels deal with. So when you enter into a record deal, they're mostly interested in your masters, whereas the publisher is mostly interested in your publishing. So these are the terms that the copyright law uses, musical composition and sound recording. Music industry uses publishing and master. So it can get a little bit confusing, but it's just important to know that these are basically interchangeable sets of terms.
All right, so just on a very, very small basis, if a student writes a composition, what's the best way for him to just sort of protect himself? Should he send it to himself through the internet, or dates it, or know in the past it was always like you put it in an envelope and you mail it to yourself and you keep it, you get a stamp mark, or is that a possible way to establish ownership by the fact that you sent it to yourself by internet or anything like that, or not?
Mostly no, but yes, in the sense that that can serve as evidence for you.
Okay.
So the law says that a copyright begins, the legal rights begin as soon as the work is fixed in a tangible form. A tangible medium of expression is the term that they use in the copyright law. So that means for the musical composition side, the moment that you have finished writing out the sheet music. It doesn't even have to be sheet music though. It could just be a lead sheet. It could just be the lyrics jotted down on a napkin. It could just be the chords and the lyrics. It could be, if you're a guitarist, it could just be the tab. Anything that serves as some tangible medium that someone else could look at and then reproduce your song from it. If you haven't written it down or fixed it in some tangible form, then copyright hasn't come into being yet. In your head, the song might exist already, but for copyright purposes, the song is not protectable until it is fixed in that form. That being said, your copyright rights, and I'm going to explain what those rights are in a second, those begin as soon as that moment of fixation occurs. So you don't have to mail it to yourself in order to protect yourself because you have those rights by operation of law as soon as the work is created.
Okay.
On the sound recording side, you don't have anything fixed until the recording is made, right? So even if you have a song that you've already maybe done a little demo version and recorded it on your phone or some other form of just recording some scratch or demo version of the song, that's enough to count as fixed for the composition, and it's enough to count as fixed for the purposes of that recording, right? The demo recording that lives on your phone, that's a recording that's eligible for copyright protection. But if you're trying to go in the studio and release this on an album or something, you don't have anything fixed until you've actually finished tracking, mixing, mastering, and the work is complete, and to your mind, it's finished and ready to be released to the world. That's when you have that moment of fixation for a sound recording, is whenever the recording is actually done. So the corollary of that is you don't have protection if it's still just an idea. If it still lives in your head, or if you haven't jotted down a lead sheet or taken a little scratch recording of it, then you don't have any protection over it. So even if you have the song not just in your head, but you've maybe told a couple people about it, or you've whistled the melody to somebody or sung the melody to somebody, but you don't have it fixed anywhere, then you don't have protection over it, and that other person you've showed the song to could legally go ahead and try to write out their own version of the song based on what you've shared with them. So even if it's as simple as just using voice memos on your iPhone to record a little demo version, that's enough to get the basic level of copyright protection over the composition. So this whole idea of the poor man's copyright or sending it to yourself in the mail, all that's really doing is it's giving you evidence of when it went into the mail, because that's a neutral third party. The post office is going to stamp it when they receive it, and that'll serve as proof. And one of the things that you'd have to do in that scenario is not open the envelope, because then it sort of voids the credibility of that stamp, right?
Is it true that the melody is the thing that's copyrightable? Because that's always been sort of a gray area that I've understood, that you couldn't copyright maybe chords. Or I noticed that there was something that just happened recently where there was a dispute over a particular groove,
right?
Which is like opens up a whole can of worms. It seems like establishing that the melody as being copyrightable makes sense, but as soon as you open up, like, how would you like if you had a swing groove,
right?
Somebody owned that swing. It's just like they're getting really whacked now.
So there isn't really a clear line, not just in the sand, but say something a little more permanent than sand. There isn't really that clear line between, you've created something that's like interesting and okay, now it's copyrightable. The basic definition is that in order for something to be copyrightable, it has to exhibit some minimum degree of creativity from a human author. So it's actually, I believe, no, I have a slide on this in another presentation, but before I get to the next one, let me just talk a little bit about that since you asked. The basic idea is that there's sort of this bar so low you can trip over it that it's a minimum degree of creativity. So there's an old case, a really important U.S. Supreme Court case, where someone tried to get copyright protection in some phone books. And they made the argument that, hey, I put hours and hours and hours into compiling all these numbers and names, printing the phone books, and the court basically said, we get that, we hear you, but that's not the standard for copyright ownership. It's not just the fact that you put a lot of work into it. It has to exhibit some minimum degree of creativity that takes it beyond just rote labor and into something that's truly creative in some way. And on the other, sort of the other end of that is that you can't get copyright protection over things that are considered the basic building blocks. So in the visual art context, you can't just get a copyright on like a simple check mark, right? But if you stylize it and you give it that nice little swoop, then all of a sudden you've got the Nike logo that maybe has the additional element of creativity that's not just a simple check mark, right? So a similar kind of analogy in music. A swing groove is just a basic building block at this point. Maybe when it was, first developed by somebody, the very first person who was doing that might have been able to say, look, no one else is doing this, but if that were to go to a court today, especially with all of the thousands of songs that are incorporating just like a basic groove like that, a court would hear opinions on both sides. Usually in a copyright infringement context, both parties are bringing expert witnesses, musicologists or music professors to weigh in on really analyzing the fine details of the music. And it wouldn't take very long for a court to realize, hey, a basic swing groove is not protectable, so you can't be guilty of copyright infringement if the thing that they're trying to protect isn't even eligible for protection in the first place. So that all being said, melody is kind of one of the most obvious things that you can copyright, because usually melodies are one of the most unique things about a song. But I think without even trying too hard, you can think of many examples of melodies that are pretty similar to one another, right? So ultimately, the standard really looks at the work as a whole. So when you're trying to get copyright protection, usually you're looking to get copyright protection over the entire song, not just one small component of it. It's not just the melody you wrote, but it's the fact that you combine that melody with this particular harmony and this particular groove underneath all of it, and it's that combination of things that's your unique song. So I say there isn't a fine line, because I can't say that there's some rule out there. It's like, as long as your melody's over a certain number of notes, you've got a copyrightable melody, because it doesn't really work that way. That being said, there have been some cases where really simple melodies, there was a Beastie Boys copyright infringement lawsuit in I want to say the mid-90s, where they took a sample from a jazz flute record that was, this very ethereal sounding flute playing, and they took like a 2-second sample of it that really was only about 3 notes of the flute playing in the original recording, and they took that sample and then they looped it like 40 times throughout the song, and then they got sued for copyright infringement for doing that without getting permission. And what the judge said is that this 3-note melody is just not enough to be a unique melody that is worthy of protection. If they had taken a sample from a different section of the song, or the original recording, that whole case could have turned out differently. It really depends on what it is that you're seeking to protect. So,
is it true that Happy Birthday is still copyright protected, or is that public domain? That's always one of those
that case
trick questions.
Was like working its way through the courts when I was in law school, and we discussed it in my copyright class, but it was not. It hadn't reached a final verdict yet, so I kind of didn't pay as much attention, and I don't remember exactly how it played out. I want to say that the judge ruled it is now in the public domain, but I'm not 100% sure of that.
Okay. Well, look, just in the interest of kind of moving to different subjects and stuff like that, let's assume that we have some students or young composers that have written something and recorded something, and they're copyright protected, or either went through the patent office, the copyright office or whatever, or just did it in a non-formal way. What are some ways that what are some important things, advice you would give to them? What do they do next in terms of like steps to be taken, in terms of like monetizing what they've done, and maybe publicizing what they do? I don't know, you know, I'm trying to get into areas, not necessarily just the legal thing, but also ways people, and also just out of curiosity, how do people consume, how do you guys consume music now? I mean, do you buy CDs or do you buy songs, or what's that? Or you do Spotify or what? Apple Music? It's streaming. Okay.
It's like Spotify. It's
Okay.
Apple's version of it.
Right, so you buy a subscription.
Yeah.
And then how do, let's say I have a song that he listens to on there or whatever, how do I get paid?
Those are all good questions.
Yeah.
So I know you don't want to get too deep into the legal nuts and bolts, but
Right.
for better or worse, a lot of that is basically what underpins the entire music industry.
Sure.
So
Yeah, good.
so I do have this slide up here. We don't
Yeah.
have to talk in too much detail about
Right.
this, but as soon as your copyright comes into being, these are the rights that you have.
Mhm.
So these are included with every copyright, whether it's musical composition, sound recording, audio-visual work like a film or a music video or something, painting. These are the core rights that are in the U.S. copyright statute that come with every work. And there's a little caveat to that. If you see here, I have this highlighted compositions and recordings. The public performance right involves things like song being played on FM or AM radio, what we call as terrestrial radio. If you walk into a hotel lobby and you hear music playing overhead, that's a public performance. Obviously, people playing live at a venue is a public performance. One little quirk of the copyright law and how it sort of developed throughout the 20th century is that the lobbying organization representing radio stations basically said, we're already paying for public performances, we don't want to also pay for the recording side. Because remember, two sides of the same coin.
Mm-hmm.
You've got a composition and recording on every single recorded piece of music, right?
Mm-hmm.
So there's a public performance right for the composition side, but there is no public performance right for the recording. So when your song plays on OZ, if you wrote the song, then you'll see some money from that.
Mm-hmm.
But if you didn't write the song and you just recorded a cover, you're not seeing any money from the FM radio play. It just doesn't exist because there's no legal right that entitles you to that. So there's no royalties or any kind of licensing fees that anybody has to pay for that. So these are really important. One sort of exception to the public performance right is that in 1998 with the Digital Millennium Copyright Act, they added a public performance right for recordings, but only for digital audio transmissions. So satellite radio, internet radio, technically streaming as well, but there's some sort of nuances there. But it only applies to recordings in the internet context and not anywhere else.
Okay.
You also have the right to make derivative works, and I actually have a whole slide on that on the next slide. But the really important rights for distributing your music, monetizing it, are really these three: reproduction, distribution, and public performance. Reproduction is making copies. And you're not just making copies when you run off copies of your CD, but you're making copies when people buy digital downloads. You're making copies when people stream. It's called an ephemeral copy because it only lasts for a split second on your computer to get the file for the streaming. It's a little bit complicated. Distribution involves selling, leasing, all of that kind of thing. So that's crucial. You have to have that distribution right in order to put your music in stores, right? Public performance, as I mentioned, refers to those radio plays, streaming, things like that. So these are the three really important ones for music. Public display is usually not applicable in the music context, but it's what it sounds like. If you are a painter and you want to put your artwork up in a museum, you are exercising your public display right. And then derivative works come into play when we talk about sampling, but we might not get that far today. So there's a whole bunch of stuff there. The basic idea, think about like someone makes a movie from a book. There's a book first, it's a New York Times bestseller or whatever, and then someone says this would make a really good movie. They have to go to the author of that book and get permission to create that movie because the movie is a derivative based on pre-existing copyright protected work. right? So in music, technically speaking, a sound recording is a derivative of a musical composition. If you already have a song written, going into the studio is necessarily a derivative of that composition. You can't just have a recording, I mean, you can, but if you have a song written first, the sound recording technically does not exist except for the fact that it's a derivative of the composition. So little technicality there, but just so you understand that concept.
And this might have something to do with a question I have, but at this point, which is when you say it's a derivative work, is there, this might open up a whole can of worms, but what constitutes fair use?
That's a good question.
For instance, if there's music that was written inspired by a specific book, and maybe you use a few quotes out of the book, do you need special permission from the author in order to record it? I guess that's to me that's if it's original music but you're using a few quotes from the book, what constitutes fair use?
It's a hard question to answer. Again, it's one of those areas where there isn't like a bright line rule, but it's a good question to ask in the context of derivative works, because you have to think of derivative works as kind of falling along a spectrum. Mm-hmm. You have derivative works that are very clearly based on a pre-existing work, and then you have derivative works that are obviously taking some elements from a pre-existing work but changing it in some way, right? And so the farther you get down that line of transforming the work, the closer you are to a possible fair use argument. But the thing is, fair use is a defense to copyright infringement. So the only way you can actually get a solid, dependable ruling of fair use is if you get sued for copyright infringement first, and a judge hears all the evidence and all the arguments and then says, yes, this is an infringement, but they've met the fair use factors, therefore our ruling is this is a fair use and you're not liable for infringement. So fair use is you already recognize that it opens up a can of worms. There is a fairly straightforward sort of test for fair use and has 4 factors that involve the purpose and character of your work. So are you, taking some pop song and turning it into chamber music? You're really like transforming it.
I'm thinking
in some
more
way.
like if you read an important work of a book, like if you ordered, The Illustrated Man, the book or something like that, and you were inspired by this book to write music inspired by the book, but it's not a derivative work. It's not taken from the book. So
if you were to stop the hypothetical right there, you're not going to be in any kind of danger, because if you're just inspired by something else and you're not actually, I guess I should get to the specifics of what infringement is, but if you're not actually using anything from the book, then it's not even a derivative, because you're not even creating a work based on a pre-existing work. You're just inspired by it, and that happens a lot. People are inspired by photographs or paintings, or sometimes the other way around. People who are painters are inspired by music that they hear. But if you start using elements from the pre-existing work, like if you have your singer recite lines from the book, now you're actually in that area of a derivative work, because you have your original composition, but you're using these pieces from the pre-existing and incorporating it into it. And that's basically what sampling is. So when you get into that territory, the first thing that I always recommend is that you try to get permission. And that's in fact one of the basic requirements in a fair use argument. Is generally people who are in court dealing with a copyright infringement lawsuit and trying to raise fair use as a defense are doing so because they already tried to get permission and somebody said no, but they still wanted to go ahead and do it anyway, and they did, right? And so, if you work with an attorney, they can really look at your work and compare it side by side, and they can come up with an assessment, based on my understanding of the law, I think that you could qualify for fair use. It's a risky thing to do, but if you've really dramatically transformed the original work to where possibly the original is not even recognizable, or the type of transformation it has undergone is just in this totally different category than what the original work was, then you may potentially have a fair use defense. One of the other major elements of fair use is the actual commercial impact. So if you create something that, for whatever reason creates a demand for your music that takes away the demand for that book, like if suddenly people want to just listen to your music and they don't want to bother going and buying the book, then the author of that book is going to have a pretty strong argument that you've totally eroded their market, and that counts against you in a fair use analysis.
Okay.
So there's a few different factors, and really it takes a judge really going through it.
And it usually doesn't get to that point unless there's money involved, right? Or
right.
If you're making a lot of money on this work that you didn't get permission from, then someone's going to try to bust you on that.
Right.
Obviously. But if it's something that's just done for the sake of doing for artistic posterity or whatever, it's probably not going to maybe go into that realm. I don't know.
Yeah, I mean, before you even get to fair use territory, there's just sort of the practical fact, which is that once copyright infringement has occurred by sort of the legal definition of what copyright infringement is, it's up to the owner of those rights to decide whether or not they want to do something about it.
Right.
So my question's along those lines. So you have working musicians, artists, whatever, who may not be, on the greatest hits, and so they see one of their what is your kind of advice to someone who feels their copyright has been infringed? Kind of first steps before they go to a lawyer, which costs a fair amount of money. Going to court costs money. I mean, what action can a working musician without getting an attorney involved take? And if they don't do anything, are they setting a precedent that, well, this person stole my work and I don't have the money to go to a lawyer? So what should they do?
Well, so the first thing to really think about kind of comes down to the money for the most part,
Sure.
which is, one thing worth looking at is this person who's infringing your work, are they profiting from it? Because if they're just infringing your work, but like they're
Right.
not that successful, or if no one's really listening to them anyway, then even though copyright infringement has occurred, there may not really be much of an incentive in it for you to stop them from doing that.
Now, if they don't do anything and say 5 years down the road they're successful, have you set a precedent that, well, you didn't do anything, so you must have been good with it?
Kind of. So you haven't necessarily set a precedent, but there is a statute of limitations. So there's a statute of limitations for copyright infringement of 3 years from the date that you discover the infringement. So if you know that somebody's infringing and you make that active decision to not do anything about it, then once 3 years have passed from that date, a court is technically going to allow you to still file suit, but that other person, their very first defense is, this isn't even a valid claim anymore. That's going to be the first thing that they say.
My last question. So I can't afford a lawyer. I see somebody's infringed my copyright. Is a letter to them, a registered letter, even though you don't go to court? I mean, how can you protect yourself beyond that 3 years without getting a lawyer involved, if you understand what I'm saying?
Well, my first recommendation would be, if it is something that you want to take action on, to not delay too much, because after those 3 years are up, there's really not a whole lot that you can do. Now, the other person might not be aware of the statute of limitations, so you could still try sending them a letter, and it may still be effective, right?
Okay.
But if they aren't amenable to that, and then you do have to go to a lawyer, the first thing the lawyer is going to tell you is, I'm sorry, but you don't have a claim anymore.
Yeah.
So you're probably not even going to get any farther, because again, it's part of our ethical duty to not file frivolous lawsuits. And if we know that our client's claim has expired because of the statute of limitations, then we're committing ethical violations by filing suit anyway. So you'll get stopped right there. So Yes, a letter is definitely sort of a good first step. And in fact, even if you went to a lawyer, that would be the first thing that happens anyway.
Okay.
You have to make some kind of contact with them and let them know, put them on notice that you're trying to enforce your rights.
Right, because I do have a friend who's a photographer, and they all of a sudden see their work on the cover of a book, which is not a real successful book, and he's not a real successful photographer, or she. And it's like, well, it's not worth pursuing because there's no money involved, i.e. from the attorney's view.
Sure.
And then attorneys, I mean, you're talking potentially a couple $100 an hour or a chunk of the thing. And if there's no money, you know what I'm getting at? It's kind of like, well, I have all these rights, but to enforce them can cost me.
Or the idea that it's not making money now, but 10 years from now,
Right.
it might be making a lot of money. But
Right,
you're
and so
up,
how
you
do
know.
you do something up front to protect you from 10 years from now, if
Well,
anything?
one of the, so if you do get to the point where you're filing a lawsuit and you're trying to actually utilize the court system to end this copyright infringement, there's two different types of relief you can get. There's damages, so if someone is really successful, you can actually claw back some of the money that they made from your work. But the other avenue is an injunction. You can actually stop them from using that. So even in that example, the book might not be very successful, but using someone's photograph as the cover of a book is clearly a commercial use. They're trying to sell copies of that book with the eye candy of that photograph as one of the major selling points.
Yeah,
right?
Photography is like a whole nother can. I mean, I ethically, to me, if someone takes a picture of me or takes a picture of course, the Mardi Gras Indians are big, they really protect themselves if they get pictured. But if someone takes a picture of Britney Spears or something like that, they own the photograph, but the actual worth of the photographs is because Britney Spears is in the photograph.
Right. So
I
that's
don't understand how
so
photographers get away with
photographs are a little trickier because it's actually the interaction of copyright and another set of legal rights. For the non-celebrity, it's your right of privacy, which is enforceable through state law tort actions. Copyright is federal. Or if you are a celebrity, there are a handful of states that recognize what's called a right of publicity, which is the right to basically commercialize and monetize your own image, which Elvis has done to great effect. And in fact, Elvis is the reason that Tennessee recognizes a right of publicity. But for the most part, it's basically just Tennessee, New York, and California that have that right. So in the Britney Spears example, she has a right of publicity because she has reached a point in her career where photos of her are part of her sort of marketplace value. And so when someone comes and takes a photograph of her and then tries to go sell it or somehow otherwise sort of profit from that photograph, yes, they do technically own the copyright in the photograph because that's just how copyright rules work. But she also has a right of publicity to not authorize photos like that if she doesn't want to. And so it's a really interesting area, and these two regimes of law are kind of in conflict over this. And it's been a subject of lawsuits fairly recently. Odell Beckham Jr. was part of one of them. He reshared a post on Instagram from a paparazzi photographer, and then they got all pissed about it and sued him for copyright infringement. So it gets kind of tricky. What you're referring to with sort of the cost-benefit analysis is sort of an unfortunate reality of being kind of a smaller scale artist. I have a number, one client in particular who came to me with what was clearly a copyright infringement case, but after I had sent a cease and desist letter, received a response, and then sent another letter to them because they clearly didn't get it, she had already racked up a couple $100s in legal fees, and the only option that I could see is that she had to sue. Because if they're not responding to the letter, the lawsuit is really your only next step to have any kind of real leverage there. And that gets very difficult to continue to maintain it. So there are some attorneys who are litigators who will work on like a commission, what they call a contingency fee, that can make that a little bit more feasible. But the early part of the process, it really is, copyright, just like trademark and patent, are all self-policing regimes. So although the FBI does enforce certain copyright things when it comes to movie piracy and things like that, for the most part, you can't call the cops to enforce your copyright. You can't say, hey, I need LAPD to go after this guy in Hollywood who's ripping off my movie or something. It's private rights. So unfortunately, it makes it a little bit more challenging.
Because there's a lot of people, artists that can't afford an attorney. So I was thinking, well, what does someone do on their own before they get to that point?
Right.
Anything.
Yeah, I mean, certainly like making contact and trying to resolve it amicably is always the best first step. I've seen a lot of examples where people try to reach out through like Instagram message or Facebook message, and I just don't think people take that kind of thing as seriously. And so they almost immediately just snap right back and say, no, this is mine, you don't have any rights, whatever, But if you send them a letter or send them an email, maybe you'll have, a little bit of a different effect. I've also found, in my experience, not only as an attorney, but even when I was working as a manager a couple of years ago, that having somebody like that writing something on your behalf gets received so much differently on the other end. And so there may be, some expense up front to hire an attorney to write a cease and desist letter for you, but in a lot of cases, that's all it's going to take for that person to stop. Even if they won't respond to the artist writing on their own behalf, they're going to get scared by a letter from a lawyer, So, and that being said, I mean, one of the reasons I got into this is because I wanted to be able to offer this type of service for people at not multiple hundreds of dollars an hour, and there just really aren't very many options in New Orleans for that. So, and I have a colleague who I don't practice with, but I do often put these kinds of presentations on, and she also charges, we both try to set our fees at pretty reasonable levels to make that more available to people. And I see that being an area that's going to continue to grow. More and more attorneys who are actually interested in working with artists, but a lot of attorneys don't know copyright law, so there's just not that many of us out there. But I think that's changing a little bit. So I have this slide up here about the difference between the author and the owner. The important distinction there is that these are technical terms in the copyright law. They come into play when you go to register your works with the U.S. Copyright Office, but also if you are working with a record label or a publisher, there's going to be some transfer of ownership. And so the important thing to know is that the author is the person who created the work. So once you've created the work, you are the author of that work forever. So even if you sell the rights or transfer those rights away somehow, you'll always be the author. Now, if you don't sell or transfer the rights, the copyright law says the person who's the author is automatically considered the initial owner of the work. But if you then choose to work with a record label or a publishing company, they're going to ask to buy some of those rights from you. So you can separate authorship and ownership. So we talk about monetizing. Where do I want to start with this? One of the really important things that I always want to stress to artists is getting control over what you own. So there's a few different steps to that process, but if you're talking about let's say you have a band and you write songs together as a band. Now, before you even play very many shows or go into the studio or do anything like that, one of the things you can do is you can get a band agreement together where you lay out things like, how are we going to divide up ownership of these songs that we wrote? How are we going to attribute authorship percentages to different people? How are we going to make decisions on how we remove a band member or add a band member or buy a van or do these other major things? So it's usually a pretty comprehensive agreement, but one of the really important things that's in there often includes something discussing the copyright rights in both the publishing and in the masters that you might end up recording. Then when the time comes to actually go into the studio, one of the really important rules in the copyright law has to do with collaboration. So when you have, Yeah, so when you have, I guess I don't have a slide specifically on this in here, but
But that's a good point. I mean, if you're a
Yeah, here we go.
okay, if you're a collective band and you, let's say someone brings in a composition, it's kind of like their composition, but the band is instrumental in putting the arrangement together and making it something that they record, and they didn't make any kind of initial agreement like you're talking about here, which is probably like 99% of the time.
Oh, yeah.
I don't know anybody that's ever said that. Oh, before we start,
Especially in the
let's do this now. But let's say that a recording is used in a movie or something like that,
Right.
and it's just a huge sum of money. Then what is the recourse for the people who were involved, or did they have any recourse if it was sort of defined that it was written by one person? But
yeah, so
it's
this is like one of probably the most important rules in copyright law, which is there's a handful of basically default provisions. So the copyright statute has some of these rules in there, but you can always modify them by contract. And this is one of probably the most important ones. So when you have that kind of scenario where people are collaborating, if you have two or more people who intend to merge their talents into one unified work, that's the legal definition, then the copyright law will recognize co-authorship of that work. And when you have co-authorship, it's the same basic idea. The initial author is automatically the owner. When you have co-authorship, you have co-ownership, hand in hand. So as long as the people who are involved have each contributed something that sort of meets that minimum degree of creativity, which creating the arrangement is definitely that.
yeah, but
in most
there's no real
situations.
mechanism for getting royalties for arrangements, right? You get royalties for being the songwriter or the publisher of a particular work, but there's nothing that I know of. Maybe it's wrong. For instance, my friend Matt Limler did a whole record on Stevie Wonder songs, and they're very elaborate arrangements, his creative arrangements. But he had to get permission from Stevie Wonder's estate to do the songs.
Right.
And when it's played on the radio and things like that, he doesn't get any of the royalties because it goes to Stevie Wonder's estate because he was the songwriter. But is there any mechanism for people who do the arrangement?
So there's nothing that is sort of built into the copyright law that provides for that. But before getting to that, I just want to get to this sort of the core rule has to do with this collaboration. So, in, let's say, more of like the pop or kind of country example where maybe you have like two people sitting down and just writing a song together, one guy's playing guitar and the other person's writing the lyrics, if they intend to create one song with that and not just one instrumental guitar track and one just a cappella vocal track, but they actually, the whole goal from the beginning is creating a song, then they're going to be considered co-authors. Right. Now, when you have, let's say, two people who are co-authors, the law is just going to say you each have 50%. Just split it evenly. If it's three people, 33 1/3, and so on. So those are the default rules, but you can always modify that with a contract. So a band agreement is like this big kind of complex, not that complex, but covers a lot more than just songwriting, but you certainly could put a contract together for just songwriting, and that's what split sheets are, right? Where you're in the studio and you just fill in people's names and the percentage of their contribution to the song. And basically what you're doing with that is you're saying, we've all agreed that I think Steve's contribution is about 15%, so we're going to give him 15%. And it really is the product of people talking about it, hashing it out amongst themselves, and then writing it down, and then all signing it so that it becomes essentially a binding contract as to...
And this has to do more with in the process of recording, right? Because, I mean, if it probably... The most common scenario would be that someone or two people bring in a composition. This is generally the melody I want to use and blah, blah, blah. But as they rehearse to record it, the drummer says, well, let's use this kind of groove, or let's do this, or let's go to this section here, let's go to that section here. So it doesn't, it's more the contributing to putting together a sound of what the recording is going to be, not necessarily the original authors of
Right.
music. Is
So-
that what split sheets are about? I mean,
Yeah, usually split sheets are used in the studio, but as you might know, like up in Nashville, there's a whole like songwriting industry. There's a bunch
Yeah.
of publishing companies
Right, sure.
along Music Row where there are guys who go to work 9 to 5 just writing songs, and they're not recording artists, and you're not ever going to see them up on a stage bigger than like the little
Right.
bars on Broadway. But then what happens is they have a contract, an employment agreement with the publisher, who then owns all of the rights usually in those songs, and then they try to go shop those songs to record labels. So this is in the country context, so I know this is a little bit different because jazz and a lot of other sort of jazz-related genres don't necessarily have this clear separation between the songwriting and the recording.
Yeah.
But the law still recognizes this clear separation because they are two separate pieces
Right,
of property,
sure.
right? So if you have like the composition mostly worked out, then typically you'll have the scenario where whoever contributed to that composition is going to be considered the authors of the musical composition. You take that into the studio, and then your authors of the recording are everybody who recorded on it. So even if, say it's 2 people wrote out the composition, but then you've got 6 guys in the band, you've got a different set of authors on the sound recording than you do on the composition,
I see.
right? So I want to actually go back to this little chart. You've got the songwriter or composer is considered the author of the composition, right? But then when you do take it into the studio, you've got the performers, the musicians, the producer. They're going to be the people who are considered the authors of that sound recording. So if the drummer is the one who decides, hey, I'm going to play this little groove, then the drummer's added some copyrightable contribution to that sound recording. I think you could probably make an argument, and this is where it gets kind of fuzzy and confusing, that did the drummer write this, add authorship to the recording, or did he also add authorship to the composition? What's going to happen when someone goes and covers that song later? Are they going to use that drummer's groove because that's what defines the song? Don't know. It's kind of it's a little bit of a case by case kind of thing, but this is where during the writing and the recording process you can actually control the ownership of these copyrights throughout with the use of contracts and talking amongst your collaborators. This is how I want to do these things, and I want to make sure that we sign contracts when we're in the studio and so on. So
now,
I wanna,
split sheets, is that something that's commonly used now? Or, I mean, do people actually do? I've never had to do that. Now I know some younger people have written those out. And who actually keeps the split sheet, that keeps the document of all that? Or you just keep a copy for yourself? Because I mean, like I said, what's more likely is nobody's going to do that, and then something down the line makes a lot of money, and then people are going to come back and say, hey, I was on that recording.
Right.
Blah, blah, blah.
Yeah, so let's take that example. So the song's, nobody had any contracts, the song's done, it's been released, it's out there in the world, got some streams, you sold some CDs and all that, and then some, Warner Brothers comes along and say, hey, we want to use this for sync in our new big blockbuster film coming out this summer.
Yeah.
First off, they have to get permission from the owner of the rights to do that. So if you have a recording, you've got potentially 2 different owners. You have the songwriter or composer on the publishing side, or maybe also even a publishing company if they have a publishing deal. And then on the recording side, you have the band, the musicians, the record label if there is one, and so on. So let's say there is a publisher and there is a record label. That makes it actually easier for the film studio because they'll just go to the label and say, hey, can we get a master use license? And then the label's going to say, sure, have you cleared the publishing side yet? Well, no, we haven't. Okay, well, when you do, we need to be paid the same amount that the publisher does. So then the film studio goes to the publisher and says, hey, we've already got a tentative clearance on the master. We need to get a sync license for the publishing. Publishing says, okay, we can quote you $5,000 for that. So publisher has to give permission because generally speaking, if you're working with a publisher, you're actually signing over to them what's known as the administrative rights. So the publishing company then is the one in charge of actually authorizing these sync licenses and trying to pitch, other recording artists to do versions of it and so on. But in the scenario you gave where nobody signed any contracts or anything, it's likely that a publishing company and a label are not even going to be involved either, because
Right.
publishers and labels are going to look for those contracts, and they're going to want to make sure that the chain of title of copyright in these songs is clear. They want to know who's the person who has the rights, who do I talk to about all of this. So let's take the publishers and labels out of the equation. You've just got a band. 2 guys wrote the composition and they brought it to their band. There's 2 other guys who were in the band and recorded it. The default copyright rules, since you don't have a contract, are going to come into play. So on the recording side, all 4 band members are going to be basically treated as 25% owners of the recording. And then the 2 guys who wrote the song are going to be considered 50% owners of the composition. So when Warner Brothers comes along, they have to contact one of those 4 musicians to clear the master, and they have to contact one of the 2 songwriters to clear the publishing. Okay? So here's a little thing about co-ownership. And this is actually a rule from sort of our basic property law. So this is applicable to co-ownership of basically all forms of property, except for Louisiana, because there's a different system here. But copyright is federal, so Louisiana's weird laws don't matter. If you are a 50% owner or a 25% owner or a 10% owner or even a 1% owner, you are a co-owner. It doesn't matter what your percentage ownership is, you're a co-owner of that property. And as a co-owner, you have the rights to do things with the whole work. So even if you only have a 1% stake, you still are legally allowed as a co-owner to issue certain kinds of licenses, like a master use license or a sync license. The catch is you can only issue non-exclusives without permission of your fellow co-owners. So let's take the master, right? You've got your drummer, your bassist, your keyboard player, and your guitarist. They're each 25% owners. Warner Brothers comes along. They only have to talk to one of those 4 people to get a master use license, as long as it's non-exclusive.
Wow.
If Warner Brothers says, we like this song so much and we're going to use it not only in this movie, but we want to use it for our spin-off TV show that we're going to do in 2021, and we want to create merchandise that uses the little audio clips from your song, we're going to do all this other stuff, so we want an exclusive license because we don't want this song affiliated with any other movie. If Warner Brothers only talks to one of the 4 co-owners, then those other co-owners technically have to also sign off on that. Now, Warner Brothers might not necessarily know that, right? Maybe they go talk to the drummer, and the drummer's like, yeah, I own everything, it's all good, you can talk to me, don't worry about it. If he goes and issues that license, then the other 3 co-owners can come to him and say, hey, look, you owe us for this share, and by the way, we didn't want to issue an exclusive license. So I don't think that it's a copyright infringement action that you'd be able to use in that scenario, because co-owners can't sue each other for copyright infringement. But there are other legal causes of action you have for that type of scenario.
And what about if you are in a recording session and you pay the people to record? They have paid the drummer $100.
Right.
That was work for hire. You're
Right.
not part of the. Is that protection, or should someone get some kind of a release that says this is work for hire and you're not going to get paid royalties?
So release is a really, really useful tool in the studio, especially if you're just, solo musician and all your other musicians who come in the studio are hired guns, right?
Yeah.
So if you're just going to pay everybody for the session and they're not actually, it's not, think about like whose name goes on the front of the album, right? If it's just your name,
Right.
and it's not, you and these other 3 guys, then you probably, in that scenario, want to be the 100% owner of all the rights, because then you don't have to split up the money, you don't have to worry about getting permission from your co-owners and all that kind of stuff. So what a release does, it's a very simple contract. Usually these are only 1 page, sometimes even less, just a couple of paragraphs. Contains language in there that basically says that I'm hiring you for this recording session for this particular song, and you agree to assign any interest in the copyright that you have to me. And what happens once that person signs that is that they have whatever copyrightable contribution they're going to give, coming up with the groove or whatever it is. By signing that contract, they basically said, I might be adding some copyrightable contributions to this song, but I'm giving you ownership of whatever that is. And so by using releases for every session player you bring in, every sideman you bring in, backup vocalists, whatever it might be, your producer as well, your engineer as well, you can ensure that through the use of these very, very simple contracts that you have that clear chain of title that you are the owner. So then when a label comes along and they say, we want to work with you and release this album, they're going to want to know, hey, are we going to have people coming out of the woodwork 10 years from now suing the label for copyright infringement?
Right.
We don't want that. Let's get all this stuff cleared up now. So this is where it becomes really important to have this whole chain of title process started while you're writing, when you're in the studio, shortly after the recording session is still okay. Even if you've already paid them and they left, you can always call them up a couple weeks later and say, hey, do you mind signing this thing? I would recommend that you not wait too long on that though, because once the music's released and it's out there and it starts making money, then they're not going to be as willing to give up their share of copyright.
Short of that, would a canceled check with a document saying this was for recording, would that be some kind of defense? Just to show that you paid somebody for a recording session? It
could serve as evidence. And so when I do get clients who come to me and I ask them, hey, did you sign any contracts? They say, no, but I did pay everybody already for the session. I'm usually like, okay, that's good, because then that means they're not expecting more from you, right? You've already paid them. Your understanding with them is that they're not looking for royalties. They're not looking for a cut of the sync license money if anything comes in later on, all that stuff. So if you have some evidence of having paid them, that can help. If they come forward after 10 years, 15 years, and there's no other, there's no emails from them, there's no other evidence that shows that they were expecting to be paid royalties, then the fact that you have your checkbook or a canceled check or something else that can serve as evidence you paid them. Even if you collect W-9s from them, that could be something that serves as evidence that you paid them once up front and that was it. But I still recommend getting this contract in place as well, because that actually has the language that transfers ownership of the property. And that's the really key thing. That's
probably one of the reasons why the big money people like the Warner Brothers and stuff like that don't want to deal with people that don't, they're not represented. So
the big money people don't want to deal with situations that don't have contracts, because then it's not clear what the chain of title is. Now, if you do go ahead and register your copyrights, that's pretty solid evidence that whoever's name appears on the copyright registration is an owner. And so they, big money, Warner, whatever, might not necessarily ask to see all these other contracts if you have the copyright already registered.
Or if you're the sole owner and the person that actually recorded everything. Because I had a friend of mine that did he did a solo trumpet recording, just solo trumpet. He was the only person on the record, blah blah blah. And it wasn't a big film company or whatever, but they paid him quite a substantial amount of money to use that, and it was very easy because he's the only one to deal with. So
I mean, if you are literally the only one, then
so if you're doing stuff with your sequencers and stuff like that, then it's only you that are contributing. It makes it more likely.
There's literally not even a need for contracts in that scenario, because there's nobody else you need to have an agreement with, right?
So, as we kind of get down to the wire here, and if you don't mind, does anybody have any other questions? Because one of the things I wanted to ask is how do you get the attention of, let's say you have some music that you've written and it's some really interesting solo sequence stuff you did with your garage band or something like that. How do you get somebody? How do you get it? How do you become marketable in those kind of situations?
Well, there's a lot of different avenues to that, and I think there's probably about as many avenues as there are genres, because what I've noticed over the years is that the music industry is kind of segmented along genre lines. So you have like a whole group of people who work for like, in the jazz context, you have a whole group of people who work for jazz festivals, and they do, they're a booking agent where their whole roster is jazz artists, and There are labels that release exclusively jazz, and you have the same thing in country, right? And there's not a whole lot of crossover in terms of the actual individual people who are involved. You have these different little silos within the music industry. So if you're in rock, play at rock clubs and contact rock labels and rock, booking agents, things like that. But what happens when people are first getting started trying to tour and things like that is you have to kind of like start somewhere. But what I've found is that the process of kind of developing yourself as an artist or working with a manager who's skilled in artist development is starting to really hone in and find the silo that your music fits under, which can be a little bit tricky because genres are a lot more fluid than they were in like the heyday of physical units being the only form of music that was being sold and monetized. The reason genres came into being was a marketing ploy. It was really just to help people identify, this is what this music's going to sound like if you pick this up and you don't otherwise recognize the artist's name, right?
But if you have like a small library of original music that you compiled over the years and things like that, and but you're relatively unknown, nobody knows who the hell you are, would it be a good advice to give to someone in that kind of situation to go to a sort of a publishing company and make some kind of deal that says, well, look, I have all this original music. If you can give it to blah 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 or whatever, then I'll split the publishing with you. You think that's a reasonable way to, in other words, you're splitting your future royalties with a company that otherwise would be trying to promote your music.
Yeah, I would say in general, there's a lot of advantages to working with a publisher or a label because they're going to come in with their machine,
right,
their network of contacts,
connections,
and if you sign a deal with them, then you're going to get the benefit of that machine working for you. So publishing deals typically involve you assigning over to the publishing company 50% of the ownership in the rights. A more traditional record label deal involved assignment of 100% of the masters to the label. And in exchange, they would give you an advance plus some kind of artist royalty. I'm sure you're familiar with this. And then basically with a label, they own the rights, so they're the ones investing in that project. And the reason they want to own the rights is because it makes it worthwhile for that investment. These days, labels are kind of changing their business models. One of the first times I noticed this was Christian Scott's first record, not his very first record, but the first one of that trilogy he did, with the red cover. I looked on the back and I saw that it was copyright Christian Scott under exclusive license to Sony or Columbia or whatever it was. And that kind of struck me as kind of a unusual thing because what it used to be is that the label was the one who had the copyright. So when you looked at the copyright notice in the liner notes, it was copyright Arista Records or something like that. But now artists are starting to retain ownership and enter into these exclusive licensing deals where they'll give a label an exclusive license to market and distribute the music for 15 years. And that gives the label enough of a tail to sort of do the initial push, but then also have it in their catalog for sync opportunities and things like that. But the sort of negative effect of that is that if labels aren't owning the rights, then they're not really investing quite the same way that they used to.
Right.
So
do you know are there any publishing companies out there that are actually looking for original music from new composers that might, might be used in soundtracks or things like that, or background, or even for commercials or internet? Because now, I mean, even if you have like if you're doing some kind of some kind of podcast or something like that, and you have music playing in the background, that is technically a violation, right? If they haven't getting the rights to use the music that's,
Yeah,
whatever.
that's, it's not technically a sync license, but it's something
No.
similar. You need to have permission to.
But I mean,
build it
are
into
people,
that.
are certain publishing companies are looking for, music by young composers? or-
So I don't know of specific publishing companies that would fall into that category just off the top of my head. I would imagine that as a general proposition that publishing companies are on some level kind of always looking for fresh talent. Now there's a hierarchy of publishing companies just like there is of labels. There's huge ones, there's
Yeah, right.
those who are just underneath them, there's mid-level, there's small independent, right? So it definitely takes some researching to kind of find the publishing companies who are out there. To my knowledge, there's basically no publishers, like real established publishers in this part of the country at all. There's plenty in Nashville, but
Yeah,
most
right.
of their work is in country and rock and pop. Plus Nashville is sort of the younger sibling of New York and LA, so a lot of the majors are basically kind of have taken over Nashville. But there's publishing companies based in Portland, based in Seattle. I imagine there are some in the Austin area. I know that, like booking agencies are very decentralized. There's booking agencies based in Colorado and North Carolina and Philadelphia who work with artists who are based everywhere. So a lot of this stuff, publishers, labels, booking agents, managers, that whole realm of the music industry is very decentralized. So it makes it a little hard to find these people, but it also means that not everything is like, Hollywood or bust, because you can find publishers and labels who are out there. Yeah.
You do booking agencies too?
Booking agencies generally book artists for live performances, typically for tour, for outside of your hometown. When you go out on a tour, you play festivals, things like that, a booking agent is usually the person who has the contacts with the festival organizers, with the venues, all of that, and they can secure performances for you and negotiate the performance fee that you'll get paid for that. There are a handful of booking agents down here, a handful of managers, but the music industry in New Orleans is still very DIY, I'll say. A lot of independent operators and not very many people coalescing into like a more formal industry quite yet.
Yeah.
I think it's
And that's really
inching
what's
toward
missing
that.
here, wouldn't you say? Because I mean,
Yeah.
the musical talent here is abundant. I mean, there's so much music happening and so many people producing music, but there just doesn't seem to be that business infrastructure to make it go to the next level.
Yeah. Now, a couple weeks ago, I read kind of an interesting little op-ed in Offbeat written by Scott Billington from Rounder Records, and
Yeah.
he argued that we don't necessarily need those entities to exist here in New Orleans because this whole industry is already so decentralized. But what we're really missing is like, he didn't use this terminology, but it's kind of that like special sauce of like putting bands together with the right producers to create albums that are full of compelling songs. And that seems to be the thing that really drives music consumption, is a compelling song. And not necessarily like a traditional folk song or country song or anything like that. It's just
But to take it to that level, it still takes it takes a fair amount of money. I mean,
Yeah.
something like Scott, he always has monetary backing behind him,
Right.
record labels and things like that.
right. And so, I think that would be a good counterpoint to what Scott said, is that
Right.
if we had somebody like Rounder based here
Yeah, right.
who could employ a couple of producers to put some recording sessions together and help, hone songs from just what somebody wrote in their bedroom to like something that's really ready to be released.
Right.
That makes a difference. So one thing I do want to talk about, hopefully it'll be fairly brief,
Sure.
but
We got a couple of minutes. Yeah.
in this sort of new music economy that we're moving into, that's heavily dependent on streaming. And really one of the reasons that I started giving these talks is that if artists are in control of their rights, if they have been careful about getting the proper contracts in place to make sure there's no random people out there who might come out of the woodwork later, so they know that they control all of their rights. There's a lot that artists can do now to get themselves out there without having to go to a publisher first or go to a label first. And really what's happening is labels and publishers are recognizing that, and you probably know this already, but labels don't have the kind of A&R staffs that they used to have. They're not going out scouting for artists anymore. They're waiting for artists to do their own thing for a little while, establish that they either have something really compelling and interesting that's just drawing fans in, or they have, you know, a professional way of doing things to where they know how to get out there and hustle and do it in a professional way.
Or they have an audience.
Or some combination of both, right? And so once someone's been out there kind of doing that, that's when labels and publishers come in and they say, yeah, you've demonstrated some value. We can work with this. Right. And that's like at its core kind of what A&R people were doing, except they weren't waiting for the money to prove itself first. They were just going on the basis of like artistic talent, which is not necessarily the metric that they're using. You know, it still is very much a factor, but you know, you can release your music independently, not just, you know, going to disc makers or whatever, but you can get your music up on all of the streaming services and digital download services through TuneCore, DistroKid, CD Baby are kind of the three most well-known digital distributor, we call them aggregators. With any of those, you can pick and choose which platforms you want to get your stuff out to. So one of the things I did with an artist I managed a couple of years ago is we worked with CD Baby, and CD Baby's like, hey, we have this list of 50 different streaming platforms around the world that we have relationships with. There's, you know, the ones you know about, like Spotify and iTunes and Apple Music and all that. But we also have deals with, you know, this other platform in Russia and this one in China and this one in Thailand. You want to just go ahead and get your stuff out to them too? And you certainly could. And in some ways, it's probably not a bad idea to do that because you immediately get international distribution. But one of the things we did is we actually unselected quite a few of those. And the whole thinking was, if we can try to put the music in fewer places and try to drive people toward just a few outlets, it'll help you know, make each of those a little bit more, you know, driving more traffic to one place rather than spreading it out over all these other ones. And one of the things that I didn't know at the time, but I've learned since, is that all of these different streaming platforms pay different rates. So there's a bit of a trade-off. You know, you work with Spotify, you're going to be paid a much, much lower per stream rate than if you go to some like much lesser known streaming platform. I wanted to say like Rhapsody or something, but that's actually out of business now. But the trade-off there is that there's not nearly as much traffic to those platforms. So even though you might be getting a higher per stream rate, there's just not as many people hearing you there. So a little bit of a, you know, tricky thing to kind of figure out.
Do people nowadays actually release recordings without being a CD itself? They just release everything completely digitally, or is that more common? That's more common.
A lot of people are doing that now.
Yeah.
Quick question for you. Are there any tools out there for an artist to track how many times a particular song has been streamed on one of these platforms? That's a good question.
Yes. So there is a service out there called Music Reports. It's a service you have to pay for. I'm not quite sure what their rates are, but as long as you have all of your copyright ownership information straight, you can enter in that information and tell them, hey, I want you guys to run a report on this album and just get me everything you have.
Because otherwise you're just basically trusting, say, Spotify to tell you, well, yeah, you streamed 50,000 times on this one song this month. You know? Right. And how do you know?
Right. It's a little self-serving for that platform.
Percentage of the bar.
Right. Right. So Music Reports is a good one.
Is that something you have to pay for, obviously?
Yeah, and I'm not sure of all the ins and outs of Music Reports, but they have a lot of different tools. They have tools for businesses that are trying to use copyrighted material as well, so they kind of work on both sides of that. Yeah.
So the platforms like CD Baby, DistroKid, like they put your music out there. It's digital distribution, but is there really like a push that they You know, do they push your music out, or is it just like it's there somewhere, like on YouTube?
The basic deal that they offer, generally no. There's not really much push involved. CD Baby does have CD Baby Pro, where they will also help with the publishing side, where they'll try to collect some of your publishing related streaming royalties and things like that. TuneCore, which actually was one of the first digital distributors, and when I was much younger, my understanding was TuneCore was the only way to get your music onto iTunes. And I think CD Baby was around, but they weren't doing digital stuff at the time. But you know, fast forward however many years, and TuneCore now has a couple of other services. They do have a division where they'll do what's called publishing administration, where you, in exchange for usually around 10, maybe 15% of your total revenues, they'll actually handle publishing administration for you, meaning like they'll collect royalties. If someone comes to you looking to get a sync license or something, they'll actually be the initial point of contact. And then you can do a little step up from that, and I believe that they do have sort of a publishing arm where they're actually doing some push stuff as well. But this is all pretty new. Like, these distributors have started to recognize that they're in a position to essentially take over for what labels and publishers were doing. And so a lot of this stuff is changing fairly quickly.